Welcome back, everybody. Apologies for the delay in how long it took us to come to our decision. As I'm sure you can appreciate, we had quite a lot to talk about, so thank you all very much for your patience. I'm going to switch microphones because I'm getting some feedback on this. Is that any better? Yes, lovely. So, this is the Licensing Subcommittee decision, Monday 9th of October 2023, in the matter of Licensing Act 2003, application for variation of a premises licence, Southsea Brunch Club, hereafter referred to as SBK, 119 Elm Grove, Southsea. All parties shall receive written confirmation of the decision and reasons. Decision. The subcommittee has considered very carefully the application for variation of a premises licence at SBK. It gave due regard to the Licensing Act 2003, the licensing objectives, statutory guidance, and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given or expanded upon at the hearing, by all parties. Human rights legislation and the public sector equality duty has been borne in mind whilst making the decision. The subcommittee noted that the application sought approval for an inner lobby at the front of the premises and an additional bar in the basement, with several proposed changes to the conditions on the existing premises licence as detailed in the application. These included the removal of a police station address that is now closed, the updating of the CCTV condition, the rewording of a condition currently preventing alcohol sales other than to persons taking table meals, save for those at the bar, to requiring substantial meals until 90 minutes before the premises closes, a reduction from 110 covers to 70 covers, and the removal of the time limit of the number allowed in the bar area. There had been representations from 12 residents. Those objecting raised concerns broadly in relation to the licensing objectives of public nuisance and crime and disorder, with issues of concern relating to irresponsible drinks promotions, patrons outside causing noise, noise from within the premises, nuisance in the form of blocking pavements, litter, vomiting and urination in the street and near to the premises, as well as crimes such as drug taking in the locality, criminal damage, etc. It is stressed that the premises have an impact on a residential area. After having heard all of the above evidence, the subcommittee determined to grant the proposed application in part and subject to amendment as set out below. Layout amendment to include additional bar and an internal lobby at the entrance. This part of the application is approved as applied for. Amending condition 1 in Annex 2 to remove the address of the police station. This part of the application is approved as applied for. Amend condition 2 in Annex 2 on CCTV. This part of the application is approved as applied for. Amending condition 3 in Annex 2 to substantial food will be available to order until at least 90 minutes before the premises closes. This part of the application is approved, save for adding clarification to the condition as follows. The clarification is defining substantial food as food items prepared or cooked on the licensed premises and that are typically served as a main course or entree. Removing conditions 1 and 3 in Annex 3. The removal of condition 1 in Annex 3 is approved, and for clarification, that is the limit of number of people at the bar. The removal of condition 3 in Annex 3 is refused, and the existing condition is to be amended to read as follows. The premises licence holder shall ensure that staff, and when so employed SIA accredited door staff, supervise the orderly departure of patrons from the premises to minimise noise nuisance. To amend condition 5 in Annex 3 to there will be a minimum of 70 seats available when the premises are open. This part of the application is refused, and the condition shall be amended to read as follows. There will be a minimum of 85 restaurant covers available at all times the premises are open. In addition, the subcommittee has determined to amend condition 2 of Annex 3 to read, the premises licence holder shall ensure that all external doors and windows shall remain closed while the premises are open for business, save for access and egress. Reasons. The subcommittee accepted advice that it was considering the application to vary only, i.e. whether the premises ought to be granted the changes sought and not a general review of the premises licence. The subcommittee also accepted advice that it must focus its attention on the licensing objectives and cannot take issues that have not been formally raised in written representations into account. The subcommittee listened very carefully to residents' concerns and has had to balance those concerns against the interests of the business. In doing so, it has had to determine the extent of the impact that the proposed variation might have upon the licensing objectives of the prevention of public nuisance and crime and disorder. The hearing was unusual in that parts of the application had already been put in place, for example the lobby, the basement bar and an apparent change in the focus of trading. A previous hearing had imposed conditions clearly intended to limit the potential for nuisance that might be caused by a vertical drinking establishment rather than a premises primarily focused on food and restaurant use. The subcommittee heard repeated reassurance from the premises that its intention was to operate as a restaurant, but to allow flexibility for tables to be flipped and for patrons to remain after having eaten. The subcommittee heard evidence that the premises have been operating with typically 80 to 85 covers and that this was most definitely a restaurant. The intention was to continue running as such. Reducing covers to only 70, the subcommittee felt, would likely lead to a disproportionate amount of drinkers compared to diners, particularly given the restriction on the number of patrons at the bar, and now bars, has been removed. It was noted that the police and environmental health in particular had not made representations, notably following agreed amendment of the CCTV condition and introduction of the acoustic lobby. It was accepted by the subcommittee that the inference as a result is support of the application from the lead authority for the prevention of crime and disorder and prevention of public nuisance objectives. However, appropriate weight was attached to the clear strength of residents' representations. First-hand evidence was heard from residents that the premises had significantly increased antisocial behaviour and the issues complained of generally since it had operated under its latest or current management. It is unusual that such a large number of residents should express these concerns. It is unfortunate and disappointing that the application is a result of complaints received regarding noise and non-compliance with conditions, meaning it is a retrospective attempt to regularise the change in the business already in force. While it is accepted that flexibility may mean the business has increased viability, this has had to be balanced against the interests of the residents and the licensing objectives of the prevention of crime and disorder and public nuisance. The subcommittee is keen to support and endorse a successful restaurant, but recognises and acknowledges the residents' concerns given the level of antisocial behaviour in the area in general. The subcommittee heard and accepted that not every instance of antisocial behaviour could necessarily be attributed to the premises, but on the balance of the evidence that it heard determined that there was some impact on the licensing objectives in the vicinity of the premises. Accordingly, it was considered appropriate to implement some safeguards to ensure that sufficient restaurant provision remains in place at all times. The removal of the limit at the bars means that queuing outside the premises should be reduced. The subcommittee has noted the strength of assertions regarding the nature of the business to be conducted and would stress that there is a process of review if the premises changes or is not run genuinely as a restaurant with ancillary alcohol provision. A review can be brought by residents or responsible authorities in due course. There is a right of appeal for all parties to the Magistrates' Court, and formal notification of the decision will set out that right in full. Does everyone understand what we've gone through there? Everyone happy? Okay, thank you very much indeed. That concludes today's hearing. Thank you all very much for your contributions today.